you're charged with aggravated assault, second-degree felony. Got a prior robbery in 2002, another robbery in 2002. After those were final, you picked up legal possession of controlled substance in 2019 and were convicted next door. Now you pick this up. If you're convicted of this, you're looking at no less than 25 years to life imprisonment. Habitual felon. What are we doing?
Judge, I explained to him he was habitual. The offer is 15 years in the pen. And he's saying that he did not commit that offense. Is that what you told him?
By 171.
Mm-hmm.
Give or take. I mean, I might be doing
I think the lady in this is the mother of his child. I don't know whether or not she wants to pursue it or not. I mean, the state would know that. I don't know.
No, it's in the state's hands. It's not hers anymore.
Yeah.
But also, you can't have any contact with this person at all. Do you understand that?
Yes, sir.
If I find out you did, your bond would be real. It'd be so fast. The bond would be pulled. You'd sit it out in jail till we get around to trying this case. Because this, number one, you're not supposed to, but trying to influence a witness is a crime in itself. That's illegal. And I know people do it and they get thrown in jail in this courtroom all the time because we catch them. They can't help themselves. They want to be in control. And this one is turned into a parking lot. Then you rammed your vehicle into the side of hers. After ramming your vehicle, began striking the window to break it. Then she sped away and continued to chase her until the police arrived to help her at the Parkdale Mall parking lot. Damage was seen at her vehicle, and it was clear that a vehicle crashing into another vehicle can cause serious bodily injury, and that's what makes it a deadly weapon, because it's capable of causing serious bodily injury or death if it's misused. Yes. She tried to board you, and then you rammed your vehicle into the side of hers. She was going to work and exited the vehicle, began striking the window in order to break it. Then she sped away, and then that's all this other stuff happened. Dress better than that for court, sir. That's not appropriate. It doesn't show that you really care much about how important this is. You got a bunny, you know, on your t-shirt. All right. So, but you got a serious matter. This is a minimum of 25 to life, and it's with a deadly weapon. That means whatever sentence you get, you have to serve at least one half of it before you're even parolable. I want to make sure that he's not having any contact with the victim. He does. We got to get him in here so he can go get thrown in jail.
Yes, sir.
I recognize a bully when I see one, and someone who wants to.
That statement hits hard. The judge isn't just looking at evidence, he's reading behavior, attitude, control. In cases like this, personality can influence perception just as much as facts.
Control. And here, this is a woman, a girl. You need to pick on other people, maybe. Other men, maybe, not girls. That's not manly. Especially someone you're supposed to care about. What would you do to somebody you didn't like? Huh? That's rhetorical question needs to be answered here. What is his bond anyway? Condition of the bond that was set wherever that he has no contact over, obviously.
Judge, it's $100,000 plus a GPS device must be on home.
You have a GPS device on you? Okay. There hadn't been any problems during this period of time?
When I did speak to her about this and she didn't report any issues.
All right. Okay, Langston, what, and all this being said, what set for trial, is that what we're doing? Hmm. I know where this is headed. I mean, I've done this so long. I know. You've got you got police they see all the damage, all the damage, and this is fairly clear. But why would you go to trial? Unless you're influencing the victim on the side. We know that. It repeats itself too often.
Here's the reality check. When evidence stacks up like this, going to trial can be risky. So the question becomes, is this about proving innocence or buying time?
But it's a problem. And if it's provable, it's catastrophic because it comes out in the trial. And I've never had a defendant win in trial when it's shown that they're trying to influence the complainant. Get a resetting. This ought to be a pretty quick trial. How long can we be ready for that? Because I'm going to move it fast.
I can be ready in a couple weeks. You're right. It's not a
Okay,
lot
let's
of
put it on a
witnesses.
trial document in 4 or 5 weeks.
That's fine.
And just like that, the tone shifts. No more back and forth. This is heading straight to trial, and fast. When a judge speeds things up like this, it usually means one thing. The outcome might already be taking shape.